This is video number 7 on our extended series on the taxation of estates, gifts, and trusts.
The basis of estate property. The basis of estate property inherited from a decedent is generally one of the following: the fair market value of the property on the date of death. This is generally going to be how you value estate property. The fair market value on the date of death, either a stepped up or a stepped down basis. The fair market value on an alternate valuation date, if elected, the alternate valuation date is 6 months after the date of death. Don't be confused by this. The alternate valuation date is where you would value the estate's assets 6 months after the date of death. Do not confuse this with the due date for filing an estate tax return. The due date for filing an estate tax return is 9 months to the day after the date of death. The alternate valuation date is completely separate from that. That's where the executor can choose to value the estate's assets 6 months after the date of death. And you can only choose the alternate valuation date if the estate value and related estate tax is less than they would have been on the date of the taxpayer's death. So the executor would choose the alternate valuation date if the estate's assets have gone down in value. Okay. However, for any assets distributed to a beneficiary after death, but prior to 6 months after death, the basis for these assets is the fair market value as to the date of distribution. And I'm going to give you an example of this because I know this doesn't make any sense. I read I read this sentence to my husband and he's like, "What does that even mean?" Yeah, I know that this is confusing, but I'm going to give you an example, so just bear with me. Most of the time, when you have a person that passes away, their assets are just going to be valued at the fair market value of the property on the date of death. Most of the time, 99% of the time, let's say. But if you have a situation where a Form 706 is going to be filed, because a Form 706 has to be filed if the executor is going to choose the alternate valuation date. But the executor can choose an alternate valuation date if a Form 706 is filed, and then that would be the fair market value 6 months to the day after the date of death. The executor gets to choose this, and it's either going to be one or the other: fair market value on the date of death or fair market value 6 months after the date of death. That's the alternate valuation date. You need to know that for the test, people. Remember that. It's 6 months after the date of death. And there's a third valuation method, which I don't think you need to know for the test, but I want you to know that it exists. Most of what you're going to see is going to be either one or the other: the fair market value on the date of death or the fair market value on an alternate valuation date. But there's also a special use valuation method for real property used in a farming business or a closely held business if elected by a personal representative. So there's technically 3 ways to value the basis of estate property for a decedent. 99% of the time, what you're going to see is just this first one: the fair market value of the property on the actual date of the person's death. Okay? Basis of inherited property. On the date of his death, on March 1st, Roger had a basis of $35,000 in his main home in San Diego, which he bought in 1964. So I kind of had to look up these housing values in order to do this. And this is pretty accurate. Houses in the 60s and the 70s on the coast in San Diego, San Francisco, they were like $30,000 when I was growing up. Now it's very different, right? Okay. Roger lived on Social Security and did not have a filing requirement. His only heir and beneficiary is his daughter, Dana. The house's fair market value was $2,500,000 on the date of Roger's death on March 1st. So he bought it for $35,000 because he bought it in 1964. He bought it a long time ago. And he's just been living in it, right? And he's retired. So he's just been living in his house. And it's not like it's an income producing property or anything, but it's very valuable because this is San Diego, right? So the house's value has gone up in time. His basis was $35,000 because that's what he paid for it. But on the date of his death, the fair market value of the house was $2,500,000. It was the only valuable asset that he owned. Dana, his daughter, inherited the house after her father's death, and she decides to convert it to a rental property. So she doesn't sell it. She decides to make it into a rental property in order to generate revenue for herself. So the house passes to her, and her basis in the inherited home is $2,500,000. And this is the basis that she's going to use for depreciation on her own tax return because now it's her house, right? It passed to her, it's her house, but she doesn't live in it. She treats it as a rental. And her basis for depreciation is going to be $2,500,000 because that was the fair market value of the house on the date of her father's death. So this is a very beneficial tax treatment for her. And if she was to sell this house, if she was to decide to sell it rather than converting it to a rental, then the basis that she would use for determining whether she had a gain or loss on the sale would also be $2,500,000. So if she were to sell it for $2,500,000 exactly, then she would have no gain on the sale. Okay. Now, this doesn't always work for the benefit of taxpayers. If the house had gone down in value, let's say her father had purchased the home the year before and the house had dropped in value, because real estate can go down too, then you would have a step down basis in that case. The only reason why she gets such a beneficial tax treatment here is because he bought the house so many years ago, so it went up in value. Presumably it was like unencumbered by a mortgage by now, and she basically gets it outright and it's worth $2,500,000. So she gets a very beneficial tax treatment here. But this can also work against taxpayers if it's a situation where the asset has gone down in value, because sometimes real estate will drop too. Okay. But this is the basis of inherited property, right? It's the fair market value on the date of death. Okay. Not what he actually paid for the home. Alternate valuation date. Now, let me give you an example of that confusing line there. If the alternate valuation date is elected, if you have a situation where the executor is choosing the alternate valuation date, but the assets of the estate somehow get distributed in between the date of death and the alternate valuation date, then any assets that are distributed to the beneficiary in between those two dates, it's going to be the fair market value on the date of the distribution. This is assuming that the alternate valuation date is elected and a Form 706 is filed. So this particular scenario is only going to apply if you have a situation where the Form 706 is filed and the executor chooses the alternate valuation date. Now, what I chose in this example in order to illustrate this scenario was cryptocurrency, because I can't really think of anything that would have such a volatile valuation other than something like crypto. I mean, or stock, right? Because stock can go up wildly and drop in 6 months, depending on what type of stock it is. But this is a situation where the decedent owned cryptocurrency, okay? The fair market value on the date of death was $52,000 for the crypto that this person owned. The death was on March 1st. There's an executor, and the executor chooses the alternate valuation date. If there's no executor and there's no alternate valuation date and no Form 706 is going to be filed, then it's just the fair market value on the date of death. But in this scenario, the executor has chosen the alternate valuation date, which is 6 months after the date of death. The decedent owned crypto. It was worth $52,000 on the day that this person died. Now the cryptocurrency, this same cryptocurrency, the Bitcoin, was worth $42,000 on the alternate valuation date, which is September 1st. So if the executor chooses the alternate valuation date, then the valuation on the estate tax return would be $42,000 rather than $52,000, which means that the estate tax would be less because the value of the asset is less, which is why you would choose the alternate valuation date, or why the executor would. So you would choose the alternate valuation date when the assets are worth less. Okay, and it's 6 months after the date of death to the day. It's not any day in between. The executor can't choose any other day. It's either the date of death or 6 months after the date of death to the day. Those are the only two choices that the executor has. That's it. Okay, now, if by some chance the asset was distributed to the beneficiary in between these two dates, if the beneficiary takes possession of an asset like this crypto sometime in between these two dates, in the example that I'm giving you, if the death happened on March 1st, the alternate valuation date is September 1st, which is 6 months after March 1st. But in this example, the beneficiary took possession of the cryptocurrency on June 1st, which is in between. If that happens and assets are distributed to the beneficiary in between these two dates and the alternate valuation date is chosen, then the estate valuation on the Form 706 for the assets that were actually distributed is the distribution date that it actually occurred. So the cryptocurrency was worth $52,000 on the date of death. It was worth $42,000 on the alternate valuation date. But the cryptocurrency was actually distributed to the beneficiary on June 1st, and on June 1st, it was worth $45,000. So if the distribution occurred on June 1st and it was worth $45,000 on June 1st, then that's the valuation that would have to go on the Form 706, the $45,000, the date of the actual distribution. The way to avoid this kind of messy scenario is not to distribute any assets to the beneficiary until after the alternate valuation date has passed. But sometimes that doesn't happen, and the assets do get distributed to the beneficiary before that time. And if that does happen and the alternate valuation date is chosen, then it's the fair market value on the date of the distribution. That's what has to be reported on the Form 706. Okay? Let's talk about the Michael Jackson estate tax law case. Now, the estate of Michael Jackson versus Commissioner is my favorite case to talk about, not only because this is a very famous person who died, but the fact that the estate was in litigation so long, we have so much out there to learn from. And the case was actually decided in 2021. And for the most part, the estate won against the IRS. The estate pretty much prevailed on all of the major points. It wasn't a complete victory, but it was pretty close. It was pretty close. The executors did very well in this case. So Michael Jackson was a very famous singer. For the young folks in the audience, Michael Jackson was like the biggest thing on the planet when I was a kid and going through high school. He was extremely popular in the 80s and the 90s. And even in the early 2000s, he was still releasing records. But he died on June 25th, 2009. That's actually his date of death. He was only 50 years of age when he died. Michael Jackson drafted a will. He actually died with a will, but it was a simple will. It wasn't too complicated. He didn't have, trust set up or anything else like that. But he did actually draft a will, which many famous entertainers don't. Like I said, Prince died without a will. Aretha Franklin, another very popular singer, she died without a will. They just don't like to think about this stuff. But Michael Jackson actually did write a will. He wrote more than one. Both of his wills were submitted to the probate court. He had written an earlier will before he had children, but his most recent will was drafted on July 7th, 2002, which was a few years before he actually passed away. So he had updated his will before his passing, naming his mother and his 3 children as the beneficiaries of his estate. He named 3 executors in his will: John Branca, John McClain, and one other man who was actually an accountant. But that executor declined to serve. He actually filed paperwork with the court and said, no, I don't want to do this. And, his reasoning might have been really sound at the time. When Michael Jackson died, he was very, very heavily in debt. He had a lot of assets, but his estate was over $200 million in debt. And John Branca, who is actually a brilliant attorney who was named as the executor, one of the executors in Michael Jackson's estate, kind of is a visionary in this regard. Like, he saw the capacity for the estate to generate a ton of revenue. But at the time of Michael Jackson's death, he was very near insolvency. His estate was hundreds of millions of dollars in debt. And he had very valuable assets. He owned part of the Beatles songbook. He had his own music copyrights, which were also very valuable. He owned a lot of real property, including Neverland Ranch and his several homes. But he also had a huge amount of debt. Now, Michael Jackson's estate was valued at the time of his death It was valued by highly trained appraisers. We know who some of the appraisers are because they testified at trial during the estate tax law case. So it wasn't like this was some cockamamie slapdash thing. Appraisers were brought in. His assets were properly appraised, including his intangible assets, which were like his songs that had still been unreleased. He had a lot of unreleased songs, and those had to be valued too. And it's very difficult to value that type of an asset, even though it does obviously have value because he's a famous singer. So the estate valuation was done, and when all of his assets were added up and his enormous debt, which was enormous, was deducted from those assets, the estate valuation that was reported on the Form 706 was only $7 million. Now, the IRS came back and valued Michael Jackson's estate at $1.178 billion, over $1 billion. So as you can see, there was a huge disparity here. And the estate went into litigation with the IRS and was in litigation with the IRS for basically a decade. And the case actually didn't get solved or didn't get decided until 2021. And the IRS actually can still appeal the tax court's decision. This was decided at the tax court level. So it's possible that the litigation will continue. But personally, I don't think that the case is going to go any further than this. I don't think it's going to go any further than the tax court, although the IRS could appeal to a higher court and continue the litigation. I don't think that they will, but they could. The beneficiaries of Michael Jackson's estate were Catherine Jackson, which was his mother. Michael Jackson specifically excluded his father, who was still alive at the time of his death, but his father and him were estranged. His father has since passed away. He passed away, he was almost like 90 years old or something like that. His father was very old when he passed away. But Michael Jackson specifically excluded his father and made the beneficiaries of his estate his mother and his 3 minor children. His children were all minors at the time of Michael Jackson's death. They were all under the age of 18. They have all since become adults, even the youngest one. They're all adults now, legal adults, but they were all minors at the time of his death. He gave custody of his children in his will to Catherine Jackson, who is his mother. But he didn't want his family to be executors of his estate. He chose basically professional executors, John Branca and John McClain. John Branca is a very well-known music industry attorney, and John McClain was his friend and music industry executive. Neither one of these executors were related to Michael Jackson, but he wanted them to serve as executors. And Michael Jackson's family actually attempted to challenge the will. They wanted to take over as executors, especially Michael Jackson's father. But the court struck that down. So the court said, you know, Michael Jackson wrote a will. He had his wishes in the will, and he named John Branca and John McClain as his executors. So the family was not able to take over. The beneficiaries of Michael Jackson's estate are his family. It's his mother and his 3 children. But he didn't want his family members to be involved in the decision making of his estate. And so this is how it went. So the 2 executors were John Branca and John McClain, and the beneficiaries of his estate were Catherine Jackson and his 3 minor children. And I'm going to talk about the case because I want you to understand how the estate tax works and how a case like this goes to trial and goes through the courts. Now, I've read tons of articles about this case as well as the case itself. We're not going to actually look at the tax court docs because the case, the decision, is actually over 200 pages long and it reads like a novel. It's great reading if you want to learn more about the estate tax and tax law in general. I think it's something great to read, but you might not want to read through 200 pages. Now, this is the estate of Michael Jackson versus Commissioner. That's the name of the case, right? And if you look it up on the tax court website, that's the name that you can use to search for the actual case. A lot will come up if you put in estate of Michael Jackson versus Commissioner. There's a lot out there. There's been tons of press about this case. So, in the estate of Michael Jackson versus Commissioner, the judge that presided over the case in the tax court was Judge Mark Holmes. And like I said, the tax court case itself, the opinion reads like a novel. It's fantastic reading. It's not boring at all. But it's over 200 pages, so we can't we can't go over the whole case here. I'm pretty limited on time, and this webinar is already really long as it is. But Judge Mark Holmes, in his opinion, noted that the court focuses on the nature of the estate tax as a tax on the privilege of passing on the property that you own, basically, the decedent owns, not a tax on the privilege of receiving property. So the estate tax is a tax on the passing of property to a person's heirs or their beneficiaries after their death. It's not an income tax. When the estate filed the estate tax return, the Form 706, they valued the estate at $7 million. The IRS came back and said, this is way undervalued. Michael Jackson's estate is worth a lot more than this. And they valued the estate at over $1 billion. Now, there were three assets that the IRS took issue with, the valuation that the estate came up with. And they were all intangibles, which makes it even more difficult to argue about the value. These are intangible assets. It's not something like real estate or a car or even something like stock. The IRS was saying that the estate undervalued Jackson's image and likeness. Number two was the New Horizon Trust 2, which Jackson's interest in Sony and ATV, Sony Music, okay? And then the third valuation was Jackson's interest in Me Jack Music, which was an S corporation that he himself had formed, okay? Now, the assets under scrutiny were these three assets, but the main point of contention that the IRS had with the estate's valuation was over Jackson's image and likeness. The IRS was basically stating that Jackson's image and likeness was worth a lot more than the estate's valuation of his image and likeness. And the estate actually did have an appraiser come in and to value Jackson's image and likeness. When you have a famous person, their image and their likeness will continue to have a value even after their death. This is not just the case for someone like a famous entertainer like Michael Jackson. It can also apply to anybody else who owns very valuable intangible assets. Someone like an author, for example. Many times after an author passes away, their publisher will continue to publish books using that name. Two examples of that are Tom Clancy and V.C. Andrews. Maybe you've heard of either one of those authors. Tom Clancy wrote a very famous book called The Hunt for Red October, as well as another series of bestsellers with Jack Ryan as the main character. He died. Tom Clancy died. But the estate of Tom Clancy continued to use the name Tom Clancy on any future books in that same series. So they were continuing to use that author's name. And V.C. Andrews' estate did the same thing. And V.C. Andrews was an estate that actually went through almost identical type of litigation with the IRS about the author's name and likeness. The estate of V.C. Andrews. V.C. Andrews wrote a really popular series of books called The Children in the Attic. It's like gothic horror, gothic fiction. They were really popular when I was in high school. But V.C. Andrews wrote a series of books called The Children in the Attic, and she died. And then the publisher of her books actually came out afterwards and said that they had found a manuscript that was written by her, but it wasn't. It was written by a ghostwriter, and they put it out under V.C. Andrews' name. So of course her name still has value. It still has a value to sell books, and Tom Clancy's name still has value. So that's what we're talking about here. The image, their likeness, their name. If your name and your image and your likeness still has like the ability to generate revenue after your death, then that's an intangible asset that you have to value for estate tax law purposes. In Michael Jackson's case, this was the main point of litigation in the case. The estate valued Michael Jackson's image and likeness at $2,105 at the time of his death, which seems ridiculously low, right? Okay, right. The problem is that Michael Jackson's image had been tarnished before his death. He was involved in 2 cases where he was accused of child molestation, and he was acquitted in both of those cases. But the argument of the estate is that Michael Jackson's image and likeness didn't have a high value at the time of his death because basically nobody wanted to work with him. Nobody wanted to use his image and likeness on t-shirts or in programs or anything else like that because of those accusations that he had. I mean, I'm bringing this up because this is an argument that the estate itself made in court, saying that Michael Jackson's image and likeness was tarnished on the date of his death. Now, after his death, his songs rose in popularity again, and his image and likeness was able to be sold. One of the ways that the estate makes money is that, if you have like a performer, there are several performers in Las Vegas that do like Michael Jackson shows where they dress up like Michael Jackson and perform like him. If you want to do a show about Michael Jackson and use his name and his likeness and his music in your show, you have to pay the estate. So these performers have to pay the estate for the use of Michael Jackson's image and likeness, and the estate actually generates a huge amount of revenue off of that. But at the time of Michael Jackson's death, the value of his image was valued very low because at the time of his death, nobody really wanted to work with him. And in fact, the appraiser looked back several years to see how much Michael Jackson's image and likeness made, and it was very little money. There were years leading up to his death where Michael Jackson's image and likeness didn't even generate $1,000 in revenue. Before Michael Jackson's death, if you were like a t-shirt manufacturer and you wanted to put a famous person's likeness on a t-shirt, would you have gone to Michael Jackson and said, let me use your image and likeness on a t-shirt? Most people wouldn't have wanted to use a t-shirt with his image and likeness on it because his image was tarnished. He had been accused of child molestation. And although he was acquitted of those crimes, and he never will be convicted of any crime because now he's deceased, but those allegations were still out there, and the appraiser took that into account when valuing his image. Because remember, the valuation of a person's assets has to be made on the date of the person's death. So the argument of the estate attorneys was that Michael Jackson's image and likeness had been smeared in the years prior to his death. It had lowered in value substantially because of those allegations. Despite this fact, the value that the IRS put on Michael Jackson's image and likeness was $400 million. The IRS argued that Michael Jackson's image and likeness was still worth $400 million at the time of his death. But the court didn't buy that. The tax court didn't buy that. The IRS examiner, I felt, and the judge felt, was really reaching for the stars, like overvaluing Michael Jackson's image and likeness. Now, the tax court did come up with a higher value than the estate had come up with, but it was much lower than the IRS had estimated. The tax court came up with a valuation of Michael Jackson's image and likeness of $4,153,912. I don't know how they came to this like exact dollar amount, but this is what the tax court came up with, $4,153,912, which obviously is a lot less than the $400 million valuation that the IRS wanted. Now, the Sony catalog, which the IRS also had valued at approximately $89 million, was ultimately valued at $0 by the court. And that's not because the Sony catalog that he owned didn't have value. It's that it was highly mortgaged. Like Michael Jackson borrowed a huge amount of money against that asset. So the value was basically zero. It had a value, but there was a huge liability attached to it as well. So the court determined that the value was zero, which is exactly what the estate had valued the Sony catalog as well. Now, the only intangible where the IRS won really a victory was Michael Jackson's interest in Me Jack music. The estate had valued his interest in this asset to be roughly 2.2 million. That's how the estate valued the asset. The IRS examiner and expert estimated values between 58 million and 114 million, much, much higher than the estate's valuation. But unlike Jackson's interest in Sony, his interest in Mijak Music continued to generate income for his estate and was not burdened by insurmountable debt. And part of the reason why the estate valued this asset also very low is because the estate couldn't have imagined, I don't think, that Michael Jackson's music would continue to make so much money after his death. The estate has made huge amounts of money after his death. I think that his fans kind of remember him more fondly now than they did while he was alive. So the estate has actually made more money after his death than Michael Jackson ever made during his lifetime, if you can believe that. The estate has made over $2 billion since his death. So the valuation was much lower when the estate tax return was filed, but by the time it went to the tax court for decision, I think that the valuation experts as well as the tax court kind of said, this was undervalued by the estate. The court determined that a hypothetical buyer would be reasonable to assume that there would be a spike in the demand for Jackson's music similar to that of Ray Charles. So what they did is they kind of compared Michael Jackson's estate to other estates of famous singers who had died, like Ray Charles, who was also a famous singer. Ray Charles was never as famous as Michael Jackson, but Ray Charles also wasn't accused of molestation during his lifetime. So I feel like it's a difficult comparison to make, but the court ultimately came up with a valuation of 107 million for Michael Jackson's interest in Mijak Music, which included, his unreleased songs, any existing copyrights that he owned for music that he himself had written and things like that. So the court came up with a valuation of 107 million for that asset, which is kind of in between what the IRS valuation was and much higher than the estate's original valuation. So here's a value determination summary, basically what the court came up with, and it shows you what the estate value was as well as the IRS value, basically the difference between the two. And it's a huge difference. Remember, not all of his assets were being contested, but those particular three assets were contested. Michael Jackson's image and likeness, his interest in Sony, and then his interest in Mijak, which was the S Corp. His image and likeness was valued by the estate on the Form 706 at only $2,105. His interest in Sony was valued at zero because remember, it was heavily in debt. He had mortgaged or borrowed money against that asset. And so the estate determined that the value was zero. And then Michael Jackson's interest in Mijak was valued at $2,207,351. On the estate tax return, the value of these assets was listed at $2,209,456. That's what the estate valuation was. The IRS, on the other hand, came up with a value of almost $500 million for these same assets. This is a very different number than this one over here. So this is what the estate and the IRS were arguing about for almost 10 years. Now the court valuation was, not as high as the IRS, but not as low as the estate itself. The court valued Michael Jackson's image at about $4 million and also valued Michael Jackson's interest in Mijak at $107 million. So much higher than the estate, but even not as high as the IRS wanted, which was $114 million. The court agreed with the estate that Michael Jackson's interest in Sony was valueless. It was valued at zero because it was so heavily in debt. That particular asset, he had borrowed so much money against it that the value of that asset was zero. So the court's valuation of the estate was $111 million, which is less than 1/3 of what the IRS wanted. The IRS also wanted to impose accuracy-related penalties against the estate, and the court didn't allow that either. The court basically thought that the estate tried to do a good job. They got experts to come in and value the assets and everything else. They were meticulous in the valuations that they came up with. And like I said, it was difficult to value some of these assets. Nobody could have imagined that Michael Jackson's estate would go on to make this much money. Part of it is that John Branca is basically a genius. He's the estate executor, one of the executors that was named in Michael Jackson's will, and he's fantastic. Like, he knows the music industry backwards and forwards. And presumably the other executor, John Branca, who is a music industry executive, knows what he's doing too. So they have managed the estate extremely well after Michael Jackson's death. I would have never imagined, me personally, that Michael Jackson's estate would make this much money after his death, especially considering the turmoil surrounding his image and his likeness and everything having to do with the accusations and everything before his death. The court came up with a valuation of a little bit over 111 million, and they didn't impose any accuracy related penalties against the estate for undervaluing these assets once everything was said and done. And Judge Holmes, who was the judge that presided over this case, like I said, this case is a fantastic read. Judge Holmes says a lot of really quotable quotes during the case. It was like his magnum opus, basically reads like a novel. He summarized the future value of Michael Jackson's estate by saying, "Just as the grave will swallow Jackson's fame, time will erode the estate's income. It resurrected and then sold what became its most valuable asset to Sony before the trial. The value of what it has left, no matter how well managed, will now dwindle as Jackson's copyrights expire and his image and likeness shuffle first into irrelevance and then into the public domain." Which is true, right? No matter how famous you are, as time passes, people are going to forget you. You know, I asked my teenage son, "Do you know who Michael Jackson is? Do you know who Aretha Franklin is? Do you know who Prince is?" And he didn't know who any of them are. So these were very important, famous celebrities in my lifetime, right? I listened to all their music, but you know, what happens is time passes and then they fade into obscurity, which will eventually happen to the Michael Jackson estate as well. So this is a fantastic case. It's great reading, and I hope it has helped you understand estate valuation.
This is an extended series continued in the next video. Make sure to subscribe to our channel to get notifications for our tax law updates.